Hi, everybody. Welcome, and thank you guys for coming. So today we've got Jennifer Felton here. She's going to be going over probates, trusts, and Prop 19 and how it affects your title and escrow. And pretty much just bring her on up. And if you have any questions throughout, then you'll be answering them. They can just raise their hand, or do you want to wait till after?
No, I like you asking questions when we're talking about the topic, because then it's all relevant, right? And if I'm not clear, then I want to know, right? When I'm talking about
And we're starting with probates first.
We're starting with probate, then
we're segueing
trusts, and then we'll talk about Prop 19.
Okay, sounds good. Thanks, Jennifer.
Perfect. All right. So Sergio's going to pull up my slides. He's working on it. But thank you all for coming, and thank you guys for being here online. We're really glad to have this opportunity to get you guys some good information about handling transactions that are not the daily, resale. We don't always talk about it, but realtors are like used car salesmen. You're selling used homes, right? We're not selling brand new warranted homes. We're selling used homes. And knowing that and understanding what your product is and how to talk to your client is a huge part of you being a success in your business. So in particular, when you're selling to a family who's either in a trust or estate or probate type of situation, it's a different conversation, right? And in today's market, which has been not the best the last couple of years, right? Some of the areas that we're still seeing deals are probate, right? People are still dying. It doesn't matter how good or bad the economy is, people are still dying. So there's opportunity for work in this space, even when the economy's bad, even when interest rates are bad, even when tariffs are, turning our world upside down. I don't care what is going on. There are certain markets, people are still going to get divorced. People are still going to get married. They're still going to have kids, right? There are certain life events that if you can find ways to find people in those situations, there's opportunity. And this is one of them. So can you move the slides? Let's go to the first slide. Okay, so this is one of my favorite slides. I use this cartoon all the time. So the guy's in heaven with his car and he says, "My lawyer found a loophole." The reality is there ain't no loophole, right? We are all going to go the way of all things, and we need to be prepared and planning for that. If we don't do that, we end up in probate. So next slide, please. We're going to cover probate planning and Prop 19. So let's go to the next slide. One more. So let's start with what is probate. So I'm a lawyer, right? I go to court, and there are different types of court. So if you watch Law and Order or any of those crime shows, those lawyers are criminal lawyers, right? Most of what people think of is the criminal legal system. So those lawyers are hired by the government, right? They work for the government and they prosecute crimes. I don't do that. The government doesn't pay me. I pay them. Like all of us, right? So instead, I'm a civil lawyer. So LA law, right? My audience, you guys are in that age range, right? LA law, like my kid would say, like, what the hell is LA law, right? But we all know what LA law was, right? So that was civil law, right? So therefore, we fight over money. We fight over stuff. We fight over civil wrongs. Someone, was improperly handled my money, breach of fiduciary duty, or someone broke a contract that they entered into with me. That's the type of law that I do, and probate is a version of that. But whereas when we see a courtroom, we usually see like a criminal or a civil, probate is its own world, right? So there's actually a separate court system that is for probate. They have all their own forms and all their own systems, and they're designed to manage people's assets when they're not able to manage them themselves. So probate, we think of it as when someone dies, right? Once you're dead, hopefully you can't manage your stuff anymore. People try, right? But I had a file recently. So our law firm represents hundreds of escrow companies. So we get all the craziest, I get all the bad escrows. No good escrows come to me. I get all the bad escrows. So we have this deal, the seller died, right, in escrow, owned it as an individual, so there's no other parties that we can go to. There's no joint tenancy or anything like that. The buyer wants out of the deal. The daughter, who was the attorney in fact, so she had a power of attorney from the mom, says, fine, we can cancel. So escrow's like, so can the daughter sign with the power of attorney? What do you guys think? Can a power of attorney sign after someone's dead? No, you can't act after you're dead. A power of attorney is only giving them the rights that the person had. Those rights die with you, right? So these are things that you guys as agents need to know and understand so that you can properly guide and help. So escrow's like, well, what do we do? I'm like, there's this thing, it's called probate. So we're having to go to probate. The buyer's frustrated because one of the things and why we talk about we want to avoid probate is it's slow, it's expensive, right? A probate in Ventura County is a minimum of a year to probate an estate. In LA County, you're probably looking at 2 years. LA is awful. So the buyer's like, my deposit's sitting there, how do I get it back? So there are ways to do that, by the way. In the case I was talking about, I love to tell stories, by the way. In the case I was talking about, you can go into court, you can go in and file paperwork, and there's this thing called ex parte. Us lawyers, we like to talk in Latin to pretend like we're really smart. So ex parte means without the other parties. It's this private meeting. So you can do what's called an ex parte and ask for an emergency meeting, and we could get an order to get that money released if nobody really wants to move forward. So I said, they're going to have to go to court and do this. That's how this works. That's why we want to avoid probate, because you lose control as soon as you either lose capacity or life. Right? Because probate doesn't just handle dead people, it handles incapacitated people, right? So I've really been focused on my health of late, right? So if you've been paying attention, if you know, and I'm on all of social media, right? I've lost 100 pounds in the last 2 years. And thank you. And so I'm super into like this, like all the podcasts I listen to are on health right now. Like I'm into this thing, right? And one of the big things they're talking about, have you heard of the concept of a marginal decade? Right? So we're living longer, right? Medicine can keep us alive longer, but it's not keeping us healthy longer, right? So we're having this last 10 years of our life where we're alive, but we're not healthy. We're not able to walk. We're not able to do all the things that we used to do. So we're trying to avoid the marginal decade. The reality is probate court is full of old people who can't take care of themselves. Their kids are having to come in and manage and make decisions and get court orders. If you plan, you can avoid all of that, right? So that's what we're talking about. So next slide. So if you don't plan, you don't get to decide what happens with your stuff when you go. The concept is called intestate succession. So testate, testament, will, right? And you can do a will. We're going to talk about a will. I don't recommend it, but you can do a will. And you should do a will if you're going to not do a trust, at least do a will. But if you don't put a plan in place, the court is going to decide what happens with your stuff. And the people who've made this decision are the legislature. The legislature has passed a law that says, yeah.
I was gonna wait for you to.
Oh, so the legislature has passed a law that says, if you die without a plan, this is what happens to your stuff, right? So if you're married, your spouse is going to get stuff. If you have kids, your kids are going to get stuff. Depending upon who you have, my husband and I were at lunch having this conversation because his sister passed away. And she was married, but they were separated, but they're still married. So he gets a piece, and then they had 2 kids. So in California, if you're married, your spouse gets at least a third. If you have 1 child, your spouse gets half and your kid gets half. But if you have more than 1 child, your spouse gets a third and your kids get 2/3, no matter how many kids there are. So my husband's one of 10, right? So those 10 would be splitting 2/3 in that situation. But that's how it works. It's all statute. No one gets to vote. No one says, this woman and this man have not been living together for 10 years. He shouldn't get her stuff. It doesn't matter. None of your wishes, none of your real world is involved when the court is deciding what happens with your stuff. Very few of us want the court to decide what happens for us in any way, shape, or form, let alone when we pass away. So yeah, question.
So I'm a loan officer.
Yeah.
And what I've been told and what I've been telling my clients, and I
Yeah.
hope I haven't been telling them the wrong thing.
Yeah.
Is in California, since most of my business is California, I do other states, but most of my business is California. If you do not have a trust, so if you have nothing or just a will,
Right.
if you do not have a trust,
Yep.
all real estate has to go through probate.
It's almost true.
Okay, because what I tell all my clients are, if you don't have a trust,
Right.
I recommend getting one because God forbid something happens, even if you have a
Right.
will, any property you own is going through probate. Now probate court's going to get a percentage before anyone sees a dime.
A will does not avoid probate. Okay. So, and again, a will is better than nothing. Absolutely. But it doesn't avoid probate. But you can own property with right of survivorship.
Correct.
Right. So if I own something as a joint tenant with someone and I die, that property does not go to probate.
Correct.
Right? Because the other person is going to automatically get the property upon my death. The thing with joint tenancy, because joint tenancy is a great way to avoid probate up until what? The last man standing. At some point, there's only one left. And when that one goes, then we're in court.
So husband, wife,
Yep.
right, survivorship.
Yep.
The property goes to the woman because the man dies first.
Yes.
Which is usually what happens
That's
to
how
us.
it works.
And now the wife, who's the only one left.
Yep.
Doesn't have a trust and has
Right.
3 kids.
Yep.
When she dies, let's say she owns 1 house, 3 houses, 8 houses, they all have to go through probate because
Correct.
there's no trust.
Correct. Because title on that property via the deed is in her name. Once she's dead, no one can sign. No one can transfer title. So you need a court at that point. So, and so that's the purpose. But there are ways to avoid it. There's this thing called a transfer upon death deed, right? Which is not a trust. Huh?
How do you feel about that?
I don't like the document, but it exists, right? There is a way to have a plan that you want to put in place to have some sort of succession planning that avoids probate, but it might not get you title insurance. The title companies really don't like that document. But yes, the bottom line is, and we're going to talk about planning. I'm totally not following my slides, by the way, but I talk.
That's my fault.
We were talking when we were getting started about what does it cost to put a trust in place? Because that's the barrier there's 2 barriers to, well, I'd say this, sorry, there's 3 barriers to people doing a trust. One is they think it costs a lot of money. 2, they got to make decisions that they may not want to make, right? You got to actually make a deal with your spouse over what you want to happen, right? Most of us struggle to have those conversations and make those decisions and say what you want. And the third is we all want to pretend that we're not going to die. And the reality is that if you don't do these things, what you want isn't going to happen in any way, shape, or form, right? And our firm does prepare trust and estates. For a single person, it's $3,000. For a married couple, it's $4,000. All right. That's real money. It's not nothing. But if you die and you own $1 million piece of property in California, right? And we're not talking about your equity. You're talking about value, because probate is based on the value of your estate, irrespective of liens. The liens don't go into the calculation of value. You want to know why? Because attorneys write the laws and we get paid based upon the value of the estate. So I got $1 million property with a $900,000 loan on it, right? You wrote them a good loan, $900,000, right? And so they have $100,000 in equity, but it's $1 million probate, right? You don't know how much that attorney gets? $15,000. $15,000 is the probate fee to the attorney. Oh, and the administrator of the estate, they get a $15,000 check as well. And then the court gets their fee, and the probate referee, which is an appraiser, gets their fee. So you're looking at $40,000 of their 100 just went in costs.
Yep.
When they could have set up a plan for $4,000.
Yep.
Right? The math is not there to not do this. Right? So yes. Okay. Let's try a slide.
Do you offer financing for people to make it easier?
We'll take credit cards. So they finance it on their credit card. But yes.
If anybody raises their hand too, I can bring
Still.
this over to you so that we make sure that it goes on.
From a title escrow business perspective for you guys as real estate professionals, if we're dealing with an estate on a transaction, right? So mom and dad pass away and now the kids want to sell the property, right? So they're going to have to go to court. They're going to have to file a probate and the court is going to issue what are called letters. Okay, so this is the document that is going to be issued by the court. That's what you need before you can do anything. You can't enter into a listing agreement. You can't enter into a binding sales contract until there's authority given to someone to act on behalf of the estate. Okay, so those are words you're going to have to ask when if you're talking to a prospect who says, you know, mom and dad left this house. I'm going to be in charge of their estate. Do you have letters? If they don't have letters, they need to get letters before they can even sign a listing agreement with you.
So should they be asking an attorney, get an attorney right away?
I would get it sooner rather than later. So one of the big things with probate is there's a lot of notice requirements. We want everyone to know what's going on and give people an opportunity to make their claims. So when you file a probate, you're going to file a petition for probate. You have to publish. So like who reads the newspaper anymore? But if you read the newspaper, right, all those ads, those are required notices by the court. So they have to publish a notice before and give people time to make claims before you can even get letters, right? And then we have to do it at the end of the process as well. So again, that's why we're looking at a year-long process. Once you have letters, however, you do not have to wait till the probate is over to sell the property. And a lot of times this is a huge issue because the mortgage doesn't stop just because you died, right? Those payments have to keep being paid. If the estate's cash poor, right? It had property, but there's no cash. Who's paying the mortgage? Who's got the money? I had a case where it was a reverse mortgage. So you grunt as soon as I said that, right? Because a reverse mortgage is designed for older people, right? So this happens all the time with reverse mortgages. Someone dies, right? The mortgage company starts foreclosing, right? It's pretty quick because there's no right to keep that house and that mortgage once the person who had the reverse mortgage is dead. The family can't just take over the loan like a conventional loan, right? So in this case, this poor couple, it was a husband and wife. He had had the property before they got married. She was a second wife, right? They had every intention of her getting the house, but no one did anything. They didn't do a trust. They didn't do anything. So he was the only one on title, right? So she did get part of the property, not all of it, because intestate succession rules, his kids, adult kids got part of it, but no one had authority. We had to get authority. And then we had to go in because the house was in disrepair. And that's a common issue on probate or trust properties as well, is they haven't done the proper maintenance. So a lot of times these properties are in disrepair. So it wasn't in a position to sell reasonably if work wasn't done on it. And so it was going to take time to get it sold. So we had to go in and get a stay on the foreclosure to stop the reverse mortgage company from foreclosing so that we had time to get the house ready and get it sold and find her a place to live, because now she has to figure out where to live. She's, all of it. So all this stuff planning avoids and makes your life much better. So let's try the next slide. So when you're talking about a probate sale, right? So the person who was on title has passed away and we're using the court process in order to deal with that property. Once those letters are issued, you need to actually read them. And I know reading is not our favorite thing, but you have to look at those letters and see if it was granted with full authority or limited authority. There are two different ways that letters are issued. If it is full authority, you can sell that property and we don't have to go back to court. Okay. All you do is you have to notify, there's a notice obligation to any beneficiaries when we're selling with letters. And so you can't have shorter than a 15-day escrow because you have to give notice to the beneficiaries. Next slide, if it's limited authority, you can enter into a contract, but you can't actually perform until the court approves that sale. Okay. So why are there different times? Why is full authority granted sometimes and limited authority granted sometimes? If they had a will, the will can say whether they want to grant full or limited authority. So that's one of the reasons. The second primary reason, when someone is appointed as the administrator of an estate, in order to get full authority, they have to get a bond, and there's bonding. And so you have to have good credit. So sometimes the people who are appointed don't have the credit in order to get the bonding, in order to be able to get full authority. And so we're stuck with limited authority. Or there's a dispute, right? If we've got family fighting, then sometimes they'll grant limited authority so that there's a second layer in order to get some, get the votes of everybody in before a decision is made. Okay, yeah.
I think if you have full conservatorship, that's, when you have conservatorship on the person, like, does that give you the full?
It actually, conservatorship is different than like once they're dead, letters, probate. However, it depends also on conservatorship. So you can get authority to act for someone like an elder who's incapacitated. You can sell property they own except their principal residence, right? So if mom owned a shopping center or a vacant piece of land or a rental property, you can sell those without court, but their residence does require court because they don't want them out on the street.
I
Right.
went through this process.
I'm sorry.
About a year after like, I literally just got my
Yeah.
case closed and
Right.
released from everything. It was a year from the point that the
Right.
home sold
Yeah,
to go through all of that stuff.
right.
And then I had conservatorship over my mother. 'cause she
Yep.
had dementia.
Yeah.
So somewhere during the whole process, we were gonna go for a reverse mortgage, wasn't a good option.
Yeah.
We sold it, what we're gonna sell, and I had to go through all
Right.
that with my attorney.
Yeah.
Like you said, you gotta fix up the house, you have to get prepared, same type of thing. And then
Yeah.
my dad passed away during
Of
the
course.
sale
Yeah.
and
Mhm.
left, so she was there, but I have full conservatorship.
Right.
So everything went through me and whatever my attorney handled it. So,
Right.
but yeah, it was a crazy situation. But
Yeah.
yeah, you definitely want to have a trust or something.
Well, so
to
a
avoid all
trust
of
will
that.
deal with when you're dead, right? But you're going to want a power of attorney, which is part of a complete estate plan. And there's two different types of powers of attorney. And a full estate plan will have both. One is financial, right? So that if you can't make decisions, someone can act for you financially. And you can decide the scope of financial authority you want to give them in that document. The second is medical, your health decisions. And like I said, we're getting older, we're living longer, but we're not living healthier, right? And so we're needing more and more care, which is expensive, and we're not in as good a capacity to make decisions that we should be. So having a medical power of attorney, which says who can act for you if you can't make decisions and can make some of those life-ending decisions so that your family doesn't have to, right? So there are people who keep me on a machine as long as you can. I want to be here, right? And that's fine. If that's what you want to be, there's a plan for you. I don't want to live on a, I don't want to have, that's not life to me, right? If there's, okay, so we run on electricity. People don't think about that, but humans, it's all electricity. When you're brain dead, it means there's no electricity anymore. Once there's no electricity, I don't need to have the lights on, right? So that's the decision I want to make, but I don't want my husband or my kids to have to say, pull the plug. So I can say, once there's no electricity, pull the plug. And now no one has to be the bad guy. No one has to say, do it, right? So, but it can also manage silly little things like, and look, there's a lot of religious reasons why people make decisions about their health and well-being, right? So you can say, I'm this religion, in my religion, we do this or we don't do this, right? Like there's religions who don't want blood transfusions, right? There's ones who don't want certain medications. There's others that want things that some of us don't want, right? That's totally fine. But if you write it down and do it properly, then you can make those decisions. Okay, let's go on to the next slide.
Who assigns the administrator?
It depends. I'm a lawyer. Our answers are always, it depends. So if you put a plan in place, as far as you would do a will, your will is going to say who is going to have authority, right? And so that person is called an executor, right? An executor of a will. If you don't have a plan, the person is called an administrator, right? So the terminology is actually different in the court system. The court appoints the administrator. What happens in the real world is that the smartest, most capable, hopefully capable is a strong word. The most motivated, how's that? The most motivated child will file for probate, and unless there's a reason not to appoint them, whoever filed is going to get authority, right? So this is a race type of thing. If you got kids who don't agree, and often they will object to an administrator, right? Okay, if you do plan, do not, and you have 5 kids, do not make all 5 of your kids responsible. Pick one, because they will never agree, right? And they will eat up your estate fighting over everything, right? Pick one and tell everybody who you picked and let them know why, and stick with one. Even 2, I can tell you, in the real world is very hard. It is very hard to get 2 siblings to agree on very many things. And people who got along really well when mom and dad are alive don't talk to each other after mom and dad die. Like, they fight like cats and dogs over the stupidest things. Like, my ex-husband and his sister still fight over a pair of socks that when they were like 10 years old. This has like been a drama in their life for 50 freaking years, right? Over a damn pair of socks. So just know, when mom and dad die, all of a sudden money makes people think and act very differently than they did before mom and dad were gone. Okay, so like I said, it's expensive. It's statutory. Like I said, the court sets the fees based upon the value of the estate, but again, irrespective of the liens. So I had a client, she actually hired us, her and her husband, to prepare their estate plan, and then they never did it. You know, just because you pay me doesn't mean that I can prepare your estate plan. You got to tell me what you have, and you have to tell me what you want. And they refused to give me back the data for like 2 years. And I sent an email like weekly for like 2 years. Are you ready yet? Are you ready yet? Are you ready yet? And the big problem for the husband was he was a real estate developer. And so he was buying and selling property all the time. So the thought of having to like write it down and manage it was overwhelming to him. He had $10 million in real estate assets, right? Well, guess what happened? He died, right? Without any estate plan. Now, all that property was leveraged to the, you know what? The estate probably wasn't worth $1 million, but we had a $10 million probate, right? So, because that's what you're dealing with from a property standpoint. So these things are a big deal. They really, and it took us 2 years to probate that estate and deal with those properties, right? That could have been managed, and she could have been managing those totally on her own, fully managed without court intervention, but for them putting that plan together, right? So next slide. I'm not going to go through this one. We talked about costs. It's super expensive, just promise. The other things are, it's public, right? So this is all court public. The whole world sees it. If you do a trust, it's yours, right? Your trust is not recorded. That information is not public. Doesn't mean families don't fight. There are trusts that end up in court and become public, but that's not how they're designed to work. And that doesn't happen automatically. It only happens in dispute situations. But it is slow, expensive, and you have no control, right? So there are ways to avoid probate. The big one is doing a trust, but there's a thing called a Hegstead petition. So a Hegstead petition is a court petition that we file into probate court if we can show that the person had a trust. They have to have a trust, and they have to have wanted the property to be in the trust, but for some reason it wasn't. So where this comes up the most common is actually a title and escrow situation. What happens is they refinance their house. The lender asks them to take it out of the trust to do the loan. They take it out of the trust and they don't put it back into the trust, right? And then someone dies, and now we've died without the property being in a trust. But we can show they created the trust, they intended it, there was this transaction that resulted in it coming out of the trust. So we can file this petition, and as long as there's not a fight, an objection, and the court believes us that there was intent, then the court will put it in the trust, right? So it will actually put the property back in the trust, and there will be a court order. Then the estate, the trust, the successor trustee in a case of a trust, then can administer the estate. Without that, you have to probate that property, right? Because it wasn't in the trust. This is the thing. If we're going in probate, we're doing intestate succession. So what they wrote in their trust of who gets their stuff probably doesn't match what happens in intestate succession. So a Hegstead petition will not only get it in the trust, this will cost you $3 to $5 grand versus a probate. But then their wishes get honored. Without it, we're in intestate succession, their wishes may not be honored at all. Okay.
Is there like a time limit that they would say, okay, now this could be in 5 years, 10 years?
So this is one of the things that people don't understand about like when someone dies. Often when someone dies, they just kind of ignore it. With like the parents didn't want to deal with it, the kids don't want to deal with it either, right? So they don't fix title, they don't resolve it, and they don't need to until something happens, like they want to sell, or they need to do something like get a loan on the property, and now it's all screwed up. There's tax implications to property ownership in California because of Prop 13, right? So we have Prop 13, which for the vast majority of purposes is a really good law for anyone who owns property in California. Because in the 70s, Howard Jarvis and his buddies, actually have a slide with him on it in this presentation, they convinced Californians that we shouldn't have our property taxes increase based upon value every year. Think about what our property taxes would be if it was value-based every year. So Prop 13 sets your property taxes based upon the value at the time you acquire your property, and then it's capped at 2% a year that it can go up. So what happens is mom and dad bought a house in the 70s for $50,000, right? You could buy a house in Thousand Oaks for $50,000 in the 70s, right? It's worth $1.2 million today, okay? Mom and dad die and no one does anything. We don't notify the assessor. We don't do a deed. 5 years later, they sell it. Well, guess what? Mom and dad's death is the trigger for reassessment. So you're going to get a 5-year property tax bill because the property taxes were not being paid properly for 5 years based upon what they would have been worth. I had a guy came to me. His dad had left this apartment building, $250,000 in property taxes that got reassessed, which at the time was before Prop 19, right? So we're going to talk about, I don't know, we might talk about Prop 19, but before Prop 19, a parent-child transfer was excluded from reassessment, right? Now it's very limited, but at that time they would have not had, they could have kept the tax basis. Instead, $250,000 property tax bill because they didn't notify and then file the paperwork to keep that parent-child exclusion, right? So it's super important that you manage the estate. So the sooner the better. The court, so we do not want property not used, right? Property is a finite asset. So the laws in the US are all designed to have property being valuable and useful. So there's not a statute of limitations per se, but the longer we wait, the harder proof becomes, the more other potential problems you can have, okay? So the next thing is maybe there's a document that's screwed up, which is why our property can't be managed, right? So for example, I talked about a transfer upon death deed, right? So it's a document that allows you to say, when I die, I want this person to get my property, right? Parents will do it for their kids. You do not want to put your kids on title to your home while you're still alive, right? Do you know why?
Yeah.
What's
Because they will absorb that tax bill.
well, one, they will become an owner, right? So then it will trigger reassessment under current California law. But also say your daughter goes on title with you. Now, one, you need to get her authority to do anything with your house because she's on title. And two, what if she gets in a car accident and there's $1 million judgment against her? They can attach it to your house because she's on title to your home. So any bad things that associate with them can be hooked to you if they're on title to your property. So you don't want to be on title together unless there's a reason to be on title together. So the transfer upon death deed is a way to be able to transfer it, avoid probate, and get it where you want it. I had a case where they did a transfer upon death deed on mom's deathbed. Mom got in a car accident. She was dying in the hospital. They did a transfer upon death deed. And the problem was they didn't do it right. So it didn't have an APN number. It didn't have a legal description. So no title company would insure it. So we went to court and got the court to affirm the document so that it could be used. And once we had a court order, every title company would allow us to use the document. So that's a way to avoid a full probate. Again, with something like that, you're looking at a few grand versus tens of thousands of dollars. A lot quicker. We did these things in a couple months versus years. And the wishes of the party are observed. In that example, mom had 2 kids. She left the house to her son and so her daughter did not get any of the value of the property. So in our case, the daughter signed an affidavit saying she wasn't contesting it. So she was there with mom. She knew what mom had wanted and she honored her mom's wishes. That doesn't always happen, by the way, but in this case, she was totally on board. So that's an option. Quiet title, again, if there's title issues, can be a way. So these two are in probate court. This is civil court. So quiet title is a different type of court. So one of the things we attorneys do is we venue shop, right? If I have something I want to happen, I look at the different places I can go and the different types of causes of action I can file to try and get what I want to happen. Because I have to prove each thing you have to do when you're filing a lawsuit, each thing you're trying to prove has elements to it. Just like a purchase agreement has contingencies and you got to satisfy all the contingencies. With us as lawyers, if I'm trying to prove breach of fiduciary duty, there's elements to showing that breach. I have to prove all those conditions. So different things have different conditions and different types of court respond better or worse to different things. So we venue shop to try to get what we want. Sometimes there's an instrument that was recorded that shouldn't have been. In particular, in elder situations, mom or dad will sign over a deed to the caretaker, not really understanding, right? They might have been undue influenced or manipulated, things like that. So we can go to court and try to get that instrument, that deed that shouldn't have been done, canceled. And if we can show that it wasn't valid, the court will cancel it and it'll go back to what it was before. Again, I had a real case, husband and wife, divorced. They were on title as joint tenants to a piece of property. They agreed that they were going to stay on title as joint tenants. So the ex-wife was living in the property. The ex-husband was staying on as joint tenants with the plan that when one of them died, whoever survived would get the property. The ex-wife, right, the woman living in the property had some doc prep service convince her to do a trust. She prepares a trust. Guess what? She deeds her half to this trust, severs the joint tenancy, right? So now she's not a joint tenant anymore. So when he dies, she doesn't get the property, right? So we, in that case, actually went to court and we canceled the deed to the trust in order to get the joint tenancy back so that she got the property back. And in this case, the kids were in agreement. They knew that was what mom and dad intended. And so in our petition, the kids signed affidavits not contesting that situation, right? But this is a game, just like selling real estate, right? It's a game of chess. Court and probate, it's a game of chess. Okay, so let's go to the next slide. There is a new tool that's super important for you to know about because I do think we're going to start seeing this used in California. This went into effect April 1st of this year. Okay, and it's what's called a small estates affidavit. So California has had a small estates affidavit for decades. The idea of a small estate affidavit is just that. If you don't own very much, we want to give you a way by form to be able to transfer property without needing a probate. It works for both real estate and for personal property, but they work differently. When it's personal property, it's just a notarized form. But when it's real estate, again, we got to get a court order because title has to transfer and only a judge can transfer title. So what the problem has been, and go to the next slide, in real estate is that the threshold for real estate was so low that almost nothing qualified. So under the old rules, before April 1st, personal property was 184,500. So you had an IRA, you had a car, you had, 10 grand in the bank. You could do a small estates affidavit and not have to go to probate. But for real estate, it was 61,500. Who's got property worth less than 61,500 in California? I've done this once. Piece of property in the desert, right? And with this, it's a probate form. You actually have to go to court. So what you do with a small estate affidavit is you hire a probate referee, which is a form of appraiser. Probate referees are approved by the court. So they're appraisers who have been certified by the court to value property. Traditionally in a probate, the court will appoint the probate referee, so you don't get to pick. So like there's a panel, Ventura County has like 10 probate referees, and the court just picks. But with a small estate affidavit, you get to pick your probate referee because you're doing it before the court. So you go get a probate referee, you value the estate. If it's worth less than the statutory amount, then you can file it and you don't have to do a full probate. So go to the next slide. The numbers have changed. So starting April 1st, the value for both real estate and personal property went to 166,250. All right. So personal property and real property combined up to 166,250 avoids probate with a small estates affidavit. Real property, we still have to get a referee and go to court. But the big kicker is this principal residence exemption. So if mom's house, right, is worth $750,000 or less, right, which the median household value in California is like $890 today, right? So, that bottom 25 to 30%, they can do a small estates affidavit up to $750,000 for the principal residence and avoid probate. So it's actually going to be a really good tool. But this is the thing from a transactional real estate standpoint is we're in probate court, just like we are with a probate, but no letters are issued, right? I talked about letters and how that's a big deal. No letters are issued. What happens is you're filing a petition saying this property is worth less than $750,000. If there was no will, the court is just going to distribute that property based on the intestate succession rules. So say mom dies and there are 3 kids. The kids will get it 1/3 each. What'll happen is the court will issue an order and the 3 kids will now be on title. That means your seller is the 3 kids. It's not an executor or an administrator. That means now we got to get everybody to agree again. Good luck. But that will save you. I mean, again, you're looking at a couple grand to do something like a small estate affidavit versus tens and 20s of thousands for a full-on probate. So I think we'll start seeing this more and more with this new $750,000 threshold. Okay, so let's keep going. This is just a breakdown. By the way, Sergio and Tressa both have my slides. If you want to reach out to them, I'm glad to share anything on my slides. Okay, so keep going. So let's talk about Prop 19. How many of you remember Carr lobbying for Prop 19? How many of you voted for Prop 19? What do you think?
What do I think about it now?
Yeah,
I think it's a good thing.
you think so?
Right now.
So,
Positions that are replaced, like.
yes.
69.
Yeah, so we're going to go into it. There's 2 parts to Prop 19, right? So Prop 19 was an attempt by Carr wrote Prop 19, right? And it was done with a compromise to try and get people on board. Because I talked about Prop 13 and from the 70s and how it keeps our property taxes low. Since the 70s, there have been people saying, property owners are not paying their fair share, schools don't have enough money, right? Like that argument has been happening since Prop 13 was put in place. So there have been multiple initiatives that we voted on over the last what now, 40, 50 years, trying to get rid of Prop 13. And so far they've all failed, but the last one was really close. It's only a matter of time, in my opinion, before we lose at least some of the benefits of Prop 13. They're attacking the business side of it right now, right? So like the last proposition we had trying to throw out Prop 13 was to try and get rid of it for businesses. You know who pays the property taxes for businesses? It's not that big landowner who loans that property. It's the tenants who are paying that rent, the little small businesses who will be taxed, who barely survive as it is if you get rid of Prop 13, right? But that's not how the people who think this is a bad thing sell this, right? So Prop 19 was a compromise bill, right? What Carr wanted was Carr wanted the ability of older people, 55 and older, to be able to take their tax basis with them when they move, with the idea that if you could take your tax basis, they would sell. Carr wants more people to sell, right? Of course. So if you can sell and take your tax basis, more people will do that. And there's actually a socioeconomic reason why that's positive, because think about how our lifestyles work, right? We start out in mom and dad's home, then we get some cheesy apartment with some roommates, we buy the starter condo, we buy the big house, and then when we're ready to retire, we don't need 5 bedrooms and a pool, and right? So sizing down makes sense. But if you bought that house in 76, right? And now if you went and rebought, even if you bought down, your property taxes would be 10 times more. You're not going to go sell. You're just going to sit in that big house all by yourself, right? So the baseline idea is great. So that part of Prop 19, I think is wonderful, right? And I'll talk about what the actual rules are. The compromise was to get rid of some of the benefits to parent-child transfers that we used to have, right? So let's go to the next slide. So I'm going to skip this one. And I talked about Howard Jarvis, right? That's Howard Jarvis. So originally it was Prop 58, right? And that's from 86. So Prop 58 allowed a parent to transfer property to their child. If it was the parent's principal residence, it was exempt from reassessment, no reassessment at all. The child got to keep the tax basis. If it wasn't a principal residence, they were able to keep the tax basis up to $1 million, right? So mom had a second home at the lake, right? And so up to $1 million in reassessment would not occur on that property if she transferred it to her kid. So that's the old Prop 58. Next slide. Prop 19 changed these rules. So it only allows for a parent-child transfer now of the principal residence. So the parent had to be living in the property when the transfer occurs, and they have to have the homeowner's exemption, right? Just because you were living there isn't enough. So on your property tax bill, you need to look at your actual bill and make sure there's a checkbox for that homeowner's exemption. It'll say homeowner's exemption $7,000, right? And that $7,000 is actually stupid little law that says if it's your home, you don't, because we pay property taxes based on the value of the property. It's $7,000 less than the value if it's your home. That's the discount we give on property taxes. So the parent can then transfer it to the child, and up to $1 million in reassessment can be avoided. All right. But only if the child is going to live in the house as well. So not only did the parent have to live in it, the child has to move in. And once the child moves out, it gets reassessed. Okay. So think about 4 kids inherit. Are we all moving in to mom's house? No, only one has to, right? If they inherited jointly, one of them has to. But as soon as they move out, the benefit goes away. And you're like, how does the assessor know? Your income taxes will say where your residence is. It's all there, right?
So let's say the child moves in.
Mhm.
Are they limited on how long they can live there to go and buy another property and transfer that tax
They
base?
can't transfer the basis at all.
Oh, they can't.
The child has no ability to transfer the basis.
Oh.
No, no. That's the parent's basis. Once they leave, it goes to market, and there's no moving that basis. Okay.
I have a question. If there is more than one child,
Yes.
if one is already living in the property,
Mhm.
do they get the benefit?
Well, it depends on, they have to agree, right? Like, so think about my real world. My grandmother died, she had 5 kids, right? So my aunt was living with her, caring for her. The family agreed that my aunt would get the house and she got the title, but then all the other assets were distributed with the other kids, right? So that was a choice they all felt comfortable making. And again, like I talked about, not everybody agrees to everything. One of the biggest challenges I see as an attorney in this space is mom's taking care of the deadbeat sibling, right? And the other siblings can't stand that sibling and are annoyed as hell that mom's been taking care of them and giving mom all the, mom's been giving him all this money and taking care of them. And guess what happens? Mom dies and that kid still wants to live in the house for free, right? And their siblings are not on board with that plan at all, right? And so what'll happen is we'll end up in court, getting a court order to sell that property and evict the deadbeat sibling who won't move out. Yeah. So it's going to depend. And there's other, like my example, everybody thought it was great. It was a perfect plan. She earned it, was their idea, right? And it works out. So it's not an automatic that just because you are living there, you get the house. Okay. So that we got a $1 million limit, they have to live there. And any property that's not a residence, it reassesses to market the day they die. Okay. And again, if you don't notify the assessor, they're going to eventually find out. And when they do, they're going to retroactively reassess to the date of death. Okay. So this is the part of Prop 19 that I don't like, right? And people didn't understand this. The assessors didn't understand it. They actually had to do a cleanup bill to fix it because it was written really poorly. So that's the piece. Go to the next slide.
Is there a chance they'll change that?
Well, this was a proposition. So the only way to do it is a proposition. Okay. So someone would have to put the money up to do a proposition and get enough signatures and then get it voted in.
Didn't we have a proposition, basically the death tax proposition that
There's
we didn't get enough signatures or?
there are propositions every year. Again, Prop 13 has been under attack since Prop 13 got put in, right? So there are constantly bills, and if the legislature could change this, they would, right? And they're liberal, so we would be paying a lot more in taxes if the legislature were in charge. That this is a referendum and that the citizens have to vote is important because it allows us to have a voice. But often, I'm sure you guys know this, how they explain something and what they talk about, they don't tell you the whole story, right? There's not always good information about what something is designed to do. And not everybody can read it and understand it, right? So the second part of Prop 19, which is what Carr wanted, I think is great. Okay, so it was the old Prop 60 and Prop 90. So the different numbers have to do with parents and grandchildren. Okay, so under Prop 60 and 90, if you were over 55 years of age and you bought something lower, so the idea was for you to move down, right? So I have this 5-bedroom pooled house and I want to move into a 2-bedroom condo, right? I was buying down. I had to buy within 2 years, right? So I sell it. I have 2 years to buy. I could do it once in my lifetime. And I had to be in the same county. I couldn't leave the county, or there were these 10 counties that cooperated, right? We were one of them. Ventura was one of them. Santa Barbara was not, right? So you didn't get to retire to Santa Barbara. And Riverside, you didn't get to go to Palm Springs, right? You couldn't go to the places people want to retire to. Well, think about it if you're Palm Springs, right? All these people are coming in and we're losing all this tax money and they haven't been paying into our system. So I can understand why they didn't want it. But so these guys agreed. There were rules, right? So that's the old rule. The Prop 19, the next slide, allows it to happen for anyone who's 55 or older. I got 4 years. Disabled, or if you're a wildfire victim, right? So if your home was destroyed in a wildfire, you can buy up or down, right? So this allows you, you can actually buy up or down. You still have 2 years. And under this rule, you can actually buy the property first. You don't have to sell first, but the transfers have to happen within 2 years. You can do it 3 times in your lifetime, not just once. And we're living longer. We talked about this, right? So you might need to sell more than once. If it's a wildfire victim, it's 1 time because it's for that triggering event. But you can go anywhere in the state of California. Okay.
As many times as you needed to, not just 3 times.
No, it's 3 times. Yeah, it's capped at 3.
And how does that work when it's new construction? You're buying a new construction and you're, let's say, creating your own house?
You got 2 years. You got to take title.
Okay, but.
But you
let's say
can't-
You bought the
you-
land.
Yeah, you have to be able to live in it. It's a principal residence rule. So
It's once the property has been finished.
Yep.
Then it gets appraised so that you can
Mhm.
determine the value?
yeah, if it's vacant land, it doesn't qualify, right? So you have to live in it. That's the whole point, is being able to move your basis and not be penalized for buying a new property. Okay.
Oh, you mean, hi. Mine was about the wildfire victims.
Yes.
So, we're doing those kinds of loans right now. And so my question is, when and what is the process for them to transfer those taxes?
Right. So they have to buy the new property.
So they
Right.
close first. It doesn't happen
Yes.
during escrow.
Correct. Right. So they're going to close and then they're going to file paperwork with the assessor's office to show the property that they were in. And it had to have that homeowner's exemption. Remember how I was talking about? The property that burned down had to have been their residence, and they had
Yes.
to have had it documented as a residence with that homeowner's exemption. They have to file in the new county. There's a form to do the Prop 19 filing to move your basis.
Okay.
Okay. Yes. So that's how this works. Okay, next slide.
So is it, do you have to file with both counties, the one you're leaving and the one you're going to? Or
No.
just the county that you're?
Because it's only where the old assessor doesn't give a crap about you anymore. They're assessing the new guy. And they're very happy about it because they're assessing the new guy at market. Right now, it's not in this presentation. It's not specifically probate and title specific, but one really important thing for wildfire victims is if they're not going to sell their property, right? If they're going to keep their property value has been diminished by the fire, right? So if you look at a property tax bill, it's got land value and then it's got improvements, right? Well, that improvement's gone. Right? So, you think about a piece of property in Pacific Palisades, the land is probably $1 million to $1.5 million, and then the house was $1 million to $1.5 million, right? So you got a $3 million tax bill. You can actually apply to get the property taxes reassessed to the new value without the house on it. So you can get your property taxes lowered to land value while you're rebuilding. Once you rebuild and you get your permits, it'll go back up to the new value. And by the way, the new value is going to be higher. So you're going to owe more, but it allows you to manage some of your costs if you're going to carry that property, because you can get your property taxes lowered while it's not usable. You had a question?
Not somebody who's 70, lives up north, they
Yeah.
can sell that house and then buy it here. So
Yes.
It's probably more expensive, so they don't.
Yep.
Buy for anything. Once they buy the house and move in, then they buy for that.
Correct. Yes. And when they buy up, the way it works is, so say they sell $1 million property, right? It was valued at $1 million when they sell it. Then they buy $1.5 million. That $1 million piece they'll keep their basis. They'll be reassessed for the additional $500,000, right? So they only get reassessed to market on the difference between the value of the property they sold and what they bought. Okay. Yeah.
So regarding the wildfires, because I do a lot in Palisades and
Yeah.
Malibu.
Yeah.
So if you owned a house that burnt down
Yep.
and now you're going to rebuild it to basically how it was before,
Sort of. Yeah.
you're actually going to get punished because of the wildfires. You're going to have to pay higher taxes at the new assessed value.
Yeah. A rebuild, right? When you,
But it's like almost unfair.
there's 2 triggers to reassessment, right? One trigger for reassessment is a sale, a transfer.
Right?
The second is an improvement, right? So You can't build what was there before. And
Right.
you think about the Palisades, those homes were built in the 50s and
Right.
60s. They're going to be worth significantly more when they're rebuilt.
Right.
They're going to be reassessed at that higher amount because it's going to be based on the building value. Because you at the time those permits are issued, they're going to have taxes based upon that.
And the county's not going to do some type of exemption because of a wildfire, so you're not like.
I have not
penalized?
seen anything to that effect.
Okay,
And that didn't happen with Malibu
with
and
Woolsey,
Woolsey.
okay.
No,
my
or the
question.
Thomas fire,
Outside.
no. But they now have a $4 million house instead of a $3 million house, right? Right. They built the same thing, right? Square footage. So there's lots of rules with the wildfires, right? If you build within the same square footage, within 10%, you can improve up to 10%. You don't have to get fully re-permitted again. And you're automatically allowed to rebuild as long as you keep the size. You don't have to keep the same footprint. You have to keep the same square footage, right? So if it was 2 bathrooms, 2 bathrooms, three bedrooms, 3 bedrooms, 2-car garage, 2-car garage, but you could redesign a whole new house, right? If that fits in the space. Those new houses, if you can afford to live through rebuilding, right? Because the reality is that everyone has not been insured enough to cover the cost of rebuilding. Not only is it just super expensive, because so many homes were destroyed at the same time, the cost of materials, the cost of labor is significantly higher. We're talking about $100 a square foot to rebuild, right? To $1,000 a square foot to rebuild, right? Like those are the price ranges we're talking about. When one home burns down, it doesn't affect the market, right? And you can rebuild, and the money that's designed, you know, a properly underwritten insurance policy is going to cover that. In this case, not only do you have all the costs being higher because of the volume, you also have remediation costs. Like if you've tried to drive through Malibu Canyon of late, all you do is stop behind a dump truck. All those dump trucks are moving all that toxic waste out of Pacific Palisades, right? So all that cost is adding to it, right? All the costs, you know, they have to rebuild all that infrastructure, right? All that infrastructure for that whole city has to be rebuilt. You think there's a budget for that, right? And the plan is to rebuild all like the power lines underground. It costs 10 times more to build underground than above ground. So not only are we rebuilding with no budget, we're rebuilding at 10 times the cost with no budget. The plan, get this, LA's plan is because all the properties are going to get reassessed, right? I talked about we're going to lower the assessment value. So they're going to do actuarials, predictions of what the new property taxes are going to be when all the stuff is rebuilt. And then they're going to borrow against the property taxes that they think they're going to get in order to pay to rebuild all that infrastructure. That's how they're going to fund rebuilding. No, there's people who will lend on future income, right? So the government is going to borrow. Government borrows all the time. Huh? Private money. Yeah, there are some bonds, but like because the state has so much money, there are ways to do it. So that's how they plan to get the money to rebuild the infrastructure. But and I talked, an average home burns down, you rebuild in about 1.5 years. We're looking at a year just to get remediated before we can even start thinking about building. 3 to 4 years realistically to rebuild a home in the Palisades. And by the way, your insurance, which covers your relocation expenses, ends at 2 years. So after that first 2 years, you're covering 2 mortgages, right? Or your rent and your mortgage, right? So if you can afford to do all this, right? Not everybody can. If you have the resources, you're going to have a $4 million house where you had a $3 million house before, but there was a lot to get there, right? So those are decisions those homeowners are having to make right now.
Well, it's past 2 o'clock.
I'll keep talking.
Do you want to answer that question? Or do you
It
want?
wasn't really a question, but I know we talked about Prop 19,
Yeah.
saying they initiated that hoping that sellers, like a couple in a 5-bedroom house, would be encouraged to
It hasn't,
So-
it actually hasn't happened.
Right, I know, but I think that because it didn't, then they initiated the
Yeah.
More Homes on the Market Act, which would raise the capital gains for a couple up to $1 million.
Yes.
And for a single, have you heard any progress on that? Is that?
CAR is lobbying for, not CAR, NAR,
Okay.
right? NAR is lobbying for that. It might happen under this current administration, right? There's several pro homeowner bills that are being promoted by the National Association of Realtors that I think with the current conservative administration in the federal government have a chance. They didn't have a chance before. Might happen. But I don't think that the idea to allow seniors to move their property taxes is a good thing, right? It wasn't bad. The thing that they didn't predict, which none of us really predicted, was what happened with interest rates, right? Inflation and interest rates were just way more of a trigger because yeah, I can move my taxes, but if I sell $1 million house at a 2.5% mortgage and buy $1 million house at a 6% mortgage, my mortgage is twice as much. I don't give a shit what my property taxes are. I can't pay the mortgage, right? Even when I bought down, right? So interest rates threw a wrench in this that no one was prepared for, right?
I'm going to bring Galen up. Galen is also a partner with Sergio at 805 Title and Escrow. And so here you go.
So I was actually going to bring up a transaction that we had. And just to kind of circle back and touch on the headset petition, and the importance of that and how often we come across it in title. And it's such a sad situation. We had a scenario where this woman thought she was selling her house, right? Like all sellers do. And we get into escrow and we get the prelim, and they had refinanced at one point, forgot to deed it back in. And this woman comes in and we're telling the realtors, hey, you can't sell this house. We have a problem. And the realtors didn't understand. So you cannot sell this house. And this poor woman comes into the office and she's in tears. She's probably mid to late 70s. I don't know what to do. I can't sell my house. I need the money. This is all the money I have. So, of course, then I referred her to Jennifer. And then, it's then on their team to go clean up the mess. But I just wanted to really, kind of circle back on that and stress the importance of the role that title has and the agents have in doing a lot of preemptive research and building that team and relying on your title team, and then relying on them to make sure that they can point you in the right direction if something's not right on the title side.
You absolutely should be getting profiles, getting title information before you have any meeting with an owner. I will say one of the issues we're dealing with in title and escrow now more than ever is fraud. And in particular, seller impersonations. I had 3 last week.
Yeah.
I had 3 escrows where the seller wasn't the real person who owned that property. 3 of them last week. 2 of them closed. Okay. All right. It's a big deal. So you need to be pulling those deeds. And when you're meeting with them, looking at it, make sure who you're dealing with, verifying identifications, and making sure you're actually dealing with the proper owners of the property.
Oh, yeah.
So it wasn't like they scammed you, like they just said they were the person and the IDs weren't checked.
Yeah. So there is a notarization done in a real estate transaction. One of the big things is who controls the notary, right? So like we are encouraging escrow to manage, and there's a balancing act because of privacy and rights and all that, but you want to know who the notary is or control the notary. Or I'm a big fan of remote online notarizations, RON notarizations. So the people think they're scary because the notary and the person are not meeting in real life. However, there's a vetting that happens with a remote online notarization, a background check, similar to like when you're trying to get your credit report online. You have to answer security questions.
Where'd you live when you were 3? Yeah.
Right. Yeah.
I just sold a lot in Florida.
Yep.
I had a virtual
Right.
closing. It was great.
Yeah. And so they ask you questions to verify your identity, right? So the bad guys can't answer the security questions. The RON notary fails, then we know we have a problem. And so I'm a fan of a RON notary, or making them come in and you verify and make sure they really are who they say they are. There's 3 fake sellers. 2 of them got through. They had a bad notary, right? So we had notarized documents.
Yeah.
Right. So you got to control the notary. There's a thing called a title insurance.
You gotta check the signatures.
We don't want those.
It's
We don't want those kind of
It's a claim, right? It's a claim under a title policy because that buyer paid full consideration, but they don't have title. So now there's a claim, right? And can we get them, can we claw the money back? Can we correct title, right? Like it's a nightmare, right? So you guys are part of that process as the lender and the real estate agents. If someone calls you to sell their property and you don't know who they are, they're a scammer. Right?
Yes.
That email, I get them. I have my broker's license, right? So at least once a week, I get an email if someone wants me to sell their property. I don't freaking sell property. I know it's a scam, right? But you guys, agents can get desperate. They see a deal. They're like ready to go. When we talk to these agents afterwards, they never met them.
Right.
They, that's how they found them, right? This was some email, right? Random email that came in.
DocuSign.
It is, it's
Never
awful.
talked to them on the
Is it more like the
phone.
2005, 6, and 7 on steroids?
It is awful.
The AI that's going around.
And it's easy to fake things.
Yeah.
And so when a lot of the fraud first started, it was really easy to tell. Like you could, there was bad English. There was lots, I had one, they notarized the document, they cut and pasted, literally like scissors cut and pasted. And the signature was sideways, like on the paper. They didn't even paste it like vertical, right? They're pretty, you can tell. Nowadays, it's really easy to fake something. And people can sound and appear legitimate in ways that we would have been able to catch before. So there are services in one of my deals, the escrow officer didn't follow procedure on multiple levels, which is a huge problem.
Right.
And this is a thing, you guys get pressured and you guys are pressured from financial and business. If the clients are in a hurry, that's a red flag, right? They're in a hurry. I don't have time. We just need to get this done.
Yeah.
I understand. You got to be paying attention to those signals. There are red flags. Afterwards, right? I'm the Monday morning quarterback. Afterwards, I see 10 red flags, right? When you're in the middle of the deal and you're just trying to get your deals done, you don't catch them all. They're there.
Yeah, they are. It's usually it's a lot of vacant land. It's paid off, cash, really quick close. It's kind of all there. And it's just making sure that you A, know the warning signs, and B, don't fall for them.
Right.
Reach out to your title team, reach out to your lawyers, make sure, just have them run a little bit of info for you so you can make an educated decision, protect your seller.
And meet with people, right? Like being in person and meeting with people is still important.
And there's certain protections too. Like we've added a service that's called Certified with ID at the end. So it's giving us a ton of protection, including ID verification, where typically, right, people close wherever. They don't come into the office. It's not like some of the East Coast states where you're doing table closing. So there's a lot of protections and options and services, and you can quadruple check now. So just making sure that the team behind you does have those things in place, because it's unfortunately 3 times last week, right? It's very real. So
it's a huge issue right now.
Yeah.
It's just you getting it.
Right.
And the other attorneys that are getting it.
Oh, yeah. Well, I represent most escrow.
You do. In the whole country.
But I mean, that's Southern California pretty much, right? That's what's going on here today. All right.
Yeah.
So.
All right. Well, thank you guys. Will you be here for a little bit if
few
anybody?
minutes.
Okay, a few minutes that she'll be able to answer some questions. We thank you so much for coming. Thank you for the people that joined us on Zoom. Please reach out to me, Jackie, Terry, Sergio, or Abby to get the slides, and all of our names are basically at 805title at the end.com. So thank you guys for joining.
Thank you.